This is a video I honestly shouldn't have to do, but I've had enough of this, and the people of America should have enough of this too. Recently, had the good old U.S. Department of Justice in my house on a fake warrant, stealing my firearms and looking for meth and fentanyl. Maybe a little bit of state tax marijuana they might have found, but meth and fentanyl, that's destroying Americans' lives, and I'm not going to have anything to do with that shit, that's for sure. I'm a pro-life kind of guy. So anyway, we have this major issue, and it's not just in Montana. I'm located in Montana, obviously. It's been identified that, I think it was 23 other states have had similar issues. And that's with our public defender's department. Now, I don't know about you guys' state's public defender's department, but here in Montana, our public defender's department costs $51 million a year, which is, we just have over 1 million people here in Montana. So seriously, we're paying $50,000 a year per person for retainer of these lawyers in the public defender's department. Now that might not be a bad deal, but, I got this little snippet of information here, and this is only the first, and this was written in 2022, and that's an issue because this actually goes all the way back to 1981, and in 2002 this issue was identified and it wasn't taken care of. Let's see what this issue is exactly, and this was written by the ACLU. This is a brief of amicus curiae. Sorry if my Latin sucks. Government education, the ACLU of Montana Foundation and the American Civil Liberties Union Foundation. The argument: Montana has long resisted and neglected its obligation to ensure that the right of counsel exists for everyone. The current controversy arising out of Yellowstone County is emblematic of Montana's half-hearted commitment to uphold the constitutional right of counsel and reflects the long-standing fragility of our public defense system. This controversy is neither unique nor isolated. Amica urged this court to consider this case within the larger context of Montana's checkered history of public defense. The ACLU had to sue Montana for it to establish the Office of Statewide Public Defender. 20th century public defense in Montana was a hodgepodge of county-administered programs utterly lacking in uniform quality, standards, or accountability. The counties designated and administered their own public defense programs and were reimbursed by the state for services rendered. The state, however, failed to set standards for the provision of services, failed to exercise any supervision to ensure that the county's programs met constitutional standards, and failed to adequately fund the county programs. As far back as 1976, Montana's Constitution was ratified in 1973 because our government wasn't doing what they were supposed to do. We had to include the right to know and the right to participate in our Constitution. That's not good. The National Center for Defense Management, means that there's federal dollars spent on identifying these issues, identified numerous deficiencies with Montana's county-based system. In 1981, an overwhelming bipartisan vote, the Montana legislature passed joint resolution finding that the constitutional requirement of effective assistance of counsel for persons accused of crimes had not been achieved consistently on a statewide basis. Despite this knowledge, the legislature failed to take any significant remedial action, and in the meantime, the problem only got worse. On February 14th, 2002, the ACLU filed suit against the state of Montana and 7 of its counties, alleging a failure to adequately fund and supervise county defense programs. White versus Martz, cause number DV 2002-133, Montana's first judicial district, Lewis and Clark County, 2002. The lawsuit alleged that the state had abdicated its constitutional duty to ensure effective counsel for the poor by delegating the design and administration of those programs to its counties. Without sufficient funding or guidance, due to the lack of state oversight, county programs were plagued by a number of deficiencies, including a virtual absence of adversary counsel, high attorney caseloads, the inability of lawyers to meaningfully confer with their clients or to develop a defense, lack of investigatory and expert services, excessive plea bargaining, and unnecessary pretrial incarceration. This is starting to sound a lot like a deprivation of liberty without due process. And we have these laws. These are some of the oldest laws here in Montana. General duty of care. Every person is bound without contract to abstain from injuring the person or property of another or infringing upon any of another person's rights. Essential elements of a contract. This is good. This is good stuff here. It is essential to the existence of a contract that there be 1. Identifiable parties capable of contracting. 2. Their consent. 3. A lawful object. And 4. A sufficient cause or consideration. Who may contract? This is also a law. All persons are capable of contracting except minors, persons of unsound mind, and persons deprived of civil rights. Like an attorney. So if you are not given an attorney, you cannot take a plea agreement. Because that would be Part 7. What does that say? Illegal objects and provisions. What is unlawful? That is not lawful, which is contrary to an express provision of law, contrary to the policy of express law, though not expressly prohibited, or otherwise contrary to good morals. I don't know if throwing people in a cage and giving them a fake lawyer, that seems a little contrary to good morals. And then we go into these other things, and these are basic human rights. And this is where we really get into it. So, basic human rights. Right of protection for personally. I'm going to skip that one. Right to state's protection. Every person, while within the jurisdiction of this state, is entitled to its protection. That apparently doesn't apply if somebody accused you of something. Now here's where I really get in. So the states came after me. I've been calling them corrupt for 10 years. I'm not just on paper. I've been doing it to their face. I've been doing it on video. They're corrupt. They've written it in their own papers. I can get on the internet and I can find not just one, I can find about a dozen illegal acts against the mass public. I'm talking back in 92, they sent me to a place called Pine Hills, and they were actually drugging kids on lithium without a doctor. That's just, and the federal government found out about this, and did they punish anybody? No, they told them how to get financing so they'll quit torturing people, And we have we got a Montana State Hospital. This is a good one. Montana State Hospital is in charge with all the, the mentally ill people, the people that need extra help in society, and they've actually been neglecting people to death. People who can't take care of themselves, well, they haven't been being taken care of by the state either. They lock these people into a hospital and neglect them to death. Now, so I'm going to go into some other laws here because this is where we really have some real issues. Like retaliation. Retaliation unlawful. Civil liabilities, remedies, statute of limitations, and definitions. It is unlawful for a state agency, state officer, public officer, or public employee to retaliate or to condone or threaten retaliation against an individual who in good faith alleges waste, fraud, and abuse. Well, I have all this document here, so in good faith I've been alleging waste, fraud, and abuse. And where has that led me? Well, the state was too afraid to attack me, so they asked the federal government for a warrant to come get my guns. And they gave them a warrant, but it didn't say to seize my guns. It was just a general warrant. It was illegal. And according to Grow versus United States 2004, which was actually a Montana case where the ATF raided a Montana guy's castle, it's a waiver of qualified immunity for anybody involved in serving a general warrant. What else do we have here? We got 49-2-301. So this is under the human rights title in Montana. Retaliation prohibited. It is an unlawful discriminatory practice for a person, educational institute, financial institute, or government entity or agency to discharge, expel, blacklist, or otherwise discriminating against an individual because the individual has opposed any practices forbidden under this chapter, or because the individual has filed a complaint, testified, assisted, or participated in any manner in an investigation or proceeding under this chapter. Legislative intent. This is where it starts getting real good, guys. The legislature finds and declares pursuant to the mandate of Article 2, Section 8 of the 1972 Montana Constitution that legislative guidelines should be established to secure to the people of Montana their constitutional right to be afforded reasonable opportunity to participate in the operation of government agencies prior to the final decision of the agencies. I suppose that's why they give you a fake lawyer, so that way you feel like you had permission. Legislative intent. This is another one. This deals with my firearms and the fact that the federal government came into my house. It is the intent of the legislature to reduce or remove provisions of law that limit or prohibit the ability of citizens to defend themselves by restricting with prior restraint the right to keep or bear arms that the people have reserved to themselves in the Montana Constitution to further establish that the right to defense of a person's life, liberty, or property is a fundamental right. Roll that one over in your head for a minute there. Firearms, the ownership of firearms, the Second Amendment, the 12th Amendment of the Montana Constitution, whatever amendment you have in your state, we're all part of the United States Union. And if you look in the federal laws under 18 U.S.C. 3002, you will find the federal government is a corporation. You will find the state right above that in number 14. Number 15 identifies the federal government as corporation. Number 14 identifies the state as a territory of this corporation. It's either 2 U.S.C. 1 or 1 U.S.C. 2 identifies county and parish as a part of this federal corporation. And me and you, we're not the corporation. We might act in corporate manners here and there, but we're private individuals. We're just trying to live in society. Yes, we have to spend corporate fiat money to survive. That's a very well meticulated scheme there. We're going to go into that another day. So here's my biggest issue. In Montana, with other states, has identified, I'm not going to go into we already know firearms is right in Montana. I'd like to identify to you guys what abuse of the law and legal process is, because that's a big one. These are laws that every one of you need to know, because when your public officials start acting out, you need to set them down a peg. So these are the codes that you're going to need to know. And in the state, actually, the state doesn't like to acknowledge it, but in the state's laws, it says that the state and the federal laws all apply to the state. And the state doesn't like to apply the federal laws to the state. The state likes to let you think that the federal laws are separate from the state. But no, they very much are. I do not believe I have a copy of where that's at with me. But it's actually in the formation of government at the beginning of Montana titles. So I'd say look at the beginning of your titles. And the U.S. Constitution is very much the law in every state. And the state does not like to acknowledge it because it is harmful to the state's corporation. So right here we have one that's called loyalty and striking. And underneath it, this one's actually in the criminal code. And that's called disloyalty and asserting the right to strike against the government. Well, when you're under oath, these pretty much both say the same thing, except for the 18 one I'm going to read. It says, whoever violates the provision of section 7311 of Title 5, that's loyalty and striking, the one that was above it, that an individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he advocates overthrow of our constitutional form of government, is a member of an organization that he knows advocates overthrow of our constitutional form of government, participates in a strike or asserts the right to strike against the government of the United States or the government of the District of Columbia, is a member of an organization of employees of the government of the United States or individuals employed by the government of the District of Columbia that he knows asserts the right to strike against the government of the United States and the government of Columbia. shall be fined under this title or imprisoned not more than 1 year, a day, or both. And they are also required to be removed from office and cannot ever hold an office again if they talk out against the constitutional form of government, not this civil religion they're trying to push on us. So we go into, get into this a little bit further, and I'd like to get into, here's a couple of maxims. This will help explain it right here. Oh, right down here on the bottom. The first one, these are, I'd have to look up to find out where these come from. The government is to be subject to the law, for the law makes the government. Makes sense. Obedience makes the government, not the name by which it is called. And who is that obedience to? Well, the Constitution, because that's the only thing they sign an oath to. They do not sign an oath to obey statutes, regulations, ordinances, legislation. They only sign an oath to obey the Constitution. And don't let any one of them guys tell you anything different. All right, so here's where it's getting squishy. So Black's Law Dictionary, and we have something called the 13th Amendment, and it says that you shall not be imprisoned without being duly convicted, because if you do, that's called involuntary servitude and slavery. And so duly, let's define that term. Duly, under the Black's Law Dictionary, means in due or proper form or manner, according to legal requirements, regularly, properly, suitable, upon proper foundation, as distinguished from mere form, according to law, in both form and substance. So it's not just form, it's form and substance. The 13th Amendment reads, Section 1, neither slavery nor involuntary servitude, except as punishment for crime. So therefore, punishment for crime is slavery and involuntary servitude, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Congress shall have power to enforce this article by appropriate legislation. Congress has created appropriate legislation for the enforcement of the 13th Amendment, and this is where a lot of people fall short. And this is very, very powerful law. So let's look at some of this. So we got right here, 22 U.S.C. 7102, subsection 8. Definition of terms: involuntary servitude includes a condition of servitude induced by means of, get this, A, any scheme, plan, or pattern intended to cause a person to believe that if the person did not enter into or continue in such a condition, that person or another person would suffer serious harm or physical restraint. Or B, and B is the big one, the abuse or threatened abuse of the legal process. Threatened abuse of the legal process is involuntary servitude. If a cop comes over and says, you need to go stand over there because I say so, he just committed involuntary servitude on you. He just submitted you to physical restraint under, well, actually it's called extortion, and I'll get into that here in a minute. So the other things we need to look into is under the entirety of chapter 77. Oh, sorry guys. And I'm doing this, it's weird because I got little pictures on my damn screen. So these codes right here also see involuntary servitude. I'm just gonna read the code numbers to you. 18 U.S. Code 1584, that's involuntary servitude. 18 U.S. Code 1583, enticement into slavery. U.S. Code 1581, peonage, obstructing enforcement. And believe it or not, all of these, if you instruct enforcement on any of these, you're looking at the same punishment, which is 20 to 30 years in federal prison. That is how serious this is. Abuse of law and legal process is no joke. And when they stand out of line, when they think that their position in society is above yours, they are very much misinformed. I would like to go over one more section, which would be extortion under the Hobbs Act. And I'll see if I can find coercion too, because if you look in coercion, if you look under coercion in state or federal law, you're going to see those same words that you see under involuntary servitude. You're going to see abuse and threat and abuse of law and legal process. You're going to see any scheme, plan, pattern. You're going to see civil and criminal fraud as an act of coercion. So if the courts are saying, oh, well, here's your lawyer, and they know it's a fake lawyer, well, that's an act of civil fraud. That's an act of coercion. That makes everything they did illegal. And this is well supported in federal law. So, Oh, here's the one that I was talking about earlier. It's right here. Constitution and statutes. And in Montana, it reads, the organic law is the constitution of government, and it is altogether written. Other written laws are denominated statutes. The written law of this state is therefore contained in its constitution and statutes, and the constitution and statutes of the United States. So that means all law applies to the state, regardless of what these trained attorneys are telling you. So let's go into coercion and exactly what that is. And I don't want anybody to tell you anything different. So under the Hobbs Act, which is codified under 18 U.S.C. 1951, and this is called extortion under color of official right. And the courts have decided, and the law is, in addition to the wrongful use of actual or threatened force, violence, or fear, the Hobbs Act, 18 U.S.C. 1951, defines extortion in the terms of the obtaining of property from another with his consent, under color of official right. In fact, the color of official right aspect of the Hobbs Act derives from the common law meaning of extortion, as the Supreme Court explained in a recent opinion regarding the Hobbs Act. At common law, extortion was an offense committed by a public official who took, by color of his office, money that was not due to him for the performance of his official duties. Extortion by the public official was the rough equivalent of what we would now describe as taking a bribe, and that can be found in Evans versus United States, 1992. In order to show a violation of the Hobbs Act under this provision, the Supreme Court recently held that the government need only show that a public official has obtained a payment to which he was not entitled, knowing that the payment was made in return for official acts. While the definition of extortion under the Hobbs Act with regard to force, violence, fear, requires the obtaining of property from another with his consent induced by these means, under the color of official right provision, does not require that the public official take steps to induce the extortionate payment. It can be said that the coercive element is provided by the public office itself. Again, Evans versus United States. So, the simple abuse of office by a... Oh, I'm not done yet here. Again, in the United States versus Margioretta, the public officer's misuse of his office supplies the necessary element of coercion. Whenever a judge acts where a judge does not have jurisdiction to act, the judge is engaged in an act or acts of treason. U.S. versus Will, 1980. Cohens versus Virginia, 1821. A judge is liable for an injury caused by a ministerial act. To have immunity, the judge must be performing a judicial function. That is ex parte, Virginia. And Harper and James, the law of torts, 1956 states, the presence of malice and the intention to deprive a person of his civil rights is wholly incompatible with the judicial function. When a judge acts intentionally and knowingly to deprive a person of constitutional rights, He exercises no discretion or individual judgment. He acts no longer as a judge, but as a minister of his own prejudice. You know, that's some pretty serious shit. And I'm going to go on. I'm going to read one more thing to you. And this is found on the U.S. courts. Sorry, where the hell are we at? uscourts.com. And it's called the Rule of Law. And this is going to go into a little bit of history here. You guys might enjoy this. More than 200 years ago, Alexander Hamilton, James Madison, and John Jay, I don't think we need to identify who those are, they published a series of essays promoting the ratification of the United States Constitution, known as the Federalist Papers. In explaining the need for an independent judiciary, Alexander Hamilton noted in Federalist number 78, and you can look into this, and the Supreme Court heavily relies on the Federalist Papers for their determinations. In the Federalist number 78, that the federal courts were designated to be an intermediate body between the people and their legislatures, in order to ensure that the people's representatives acted only within the authority given to Congress under the Constitution. The U.S. Constitution is the nation's fundamental law. It codifies the core values of the people. Courts have the responsibility to interpret the Constitution's meaning, as well as the meaning of any laws passed by Congress. The Federalist number 78 states further that if any law passed by Congress conflicts with the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. That's also supported by Marbury versus Madison, 1803 or 1806, and as well as Miranda versus Arizona, 1966. And everybody's heard of the Miranda rules, so we know the prevalence of that case. All right, so nor does this conclusion by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that that where the will of the legislature declared in its statutes stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by the fundamental law rather than those which are not fundamental. The American democratic system is not always based upon simple majority rules. There are certain principles that are so important to the nation that the majority has agreed not to interfere with these areas. For instance, the Bill of Rights was passed because concepts such as freedom of religion, speech, equal treatment, and due process of law were deemed so important that, barring a constitutional amendment, not even the majority should be allowed to change them. Rule of law is a principle under which all persons, institutions, and entities are accountable to laws that are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. The courts play an integral role in maintaining the rule of law, particularly when they hear grievances voiced by minority groups or by those who may hold minority opinions. Equally before the law is such an essential part of the American system of government that when a majority, whether acting intentionally or unintentionally, infringes upon the rights of a minority, the court may see fit to hear both sides of the controversy. It goes deeper into that, you guys. Look up this one right here. That's a big one. And this isn't actually a full statement. I wish I had the full statement for that before me. I may have. Essentially what that says is that every one of us is a private attorney general. And, I'll give you. Each citizen acts as a private attorney general who takes on the mantle of sovereign. That further goes into talking about we all have the authority to stand up for the Constitution. And there are so many laws, and you start getting into this and you start looking into the federal laws. And it's interesting You're not going to, the majority of the laws out there criminalize actions against the Constitution. And I've actually filed this in the United States Supreme Court, or federal courts in the Division of Montana here. And I've challenged them for 3 crimes that are identified in the Constitution. And those 3 crimes are treason, counterfeiting, and piracy. And the way I see it is, if the states have been giving people fake trials, especially in Montana, where it's on the record for the last 50 years, well, first of all, that's treason. You know, the people said we get an attorney. If you're going to accuse us of something and try to put us in this cage, we get a competent attorney. And Montana decided we're not going to give you a competent attorney in 1981. And, well, that's still a big issue in Montana. So, treason, counterfeiting. Obviously, if you're giving people fake attorneys and you're creating trial documents off of it, well, that's counterfeiting legal documents. And what do those legal documents accomplish? Well, they bring the acts of piracy inland against the people, against the inhabitants of this American Republic. By essentially, the cops can do whatever they want. I mean, let's consider this. 80% right now of Montana, people accused of felonies in Montana, 80% of them are represented by the Public Defender's Office. So that means 80% of people accused of crimes are given a lawyer from a department who has been identified as failing for 50 freaking years. That's called domestic terrorism. You can look it up. You know, we are committing criminal acts against the generalized whole of society, and, you know, not even giving them their day in court. And the funny thing is, Montana's got what's called Montana Correctional Enterprises. You know, that's their prison organization where they, you know, they do road work, they do fire, they got fire crews, they got a 50,000 acre dairy, they got a bakery, they got a laundry, they got lumber processing. Oh, they make the license plates and the signs for the state. So believe it or not, this public defender system, this $50 million a year failure in Montana, is partially supported by property taxes, which keep going up. So that means every person in Montana is paying tax to support an unconstitutional system that may be used against you someday. And on top of that, we're putting license plates on our vehicles. So this, oh yeah, that's the other thing. So this police state, because here's the other fun fact. If we're not getting a lawyer and the police are the ones saying we're guilty and nobody's questioning what they say, then Montana has been operating a 50-year police state where our public officials say, guess what? We say you did it and you have to prove yourself innocent. I've actually been told that. I've been told that by professional lawyers in Montana when I filed grievances. They sent me a letter that says, oh, in Ravalli County, you have to prove yourself innocent. Well, I determined it's a lot easier to prove everybody corrupt. So we're going to stick with that. And hopefully I don't have to make too many more videos about this. But, you know, they raided my house going after, oh, yeah, I'd like to talk about that. They raided my house. Why? Because, well, first of all, because I object to the illegal activity that they're not just conducting against me, they're conducting against the masses. You know, and who gets more powerful? The state does. You know, but we're, you know, so Montana, so they raided my house over guns and drugs. Well, I ain't got no meth and fentanyl. I might have a little bit of like state tax marijuana, like I said, so that was technically a setup. But we have this thing in Montana that's called Gun Owners Access to Justice Act. And it says, right to bear arms protected. Remedies. The state may not burden a person's right to bear arms unless the state proves that burdening a person's right to bear arms furthers a compelling state interest and is the least restrictive means to further that interest. Well, that's funny because the state didn't they didn't burden my right to bear arms. They called the ATF to come burden my right to bear arms. A person whose right to bear arms has been burdened by the state or is likely to be burdened by the state in violation of subsection 1 may assert the violation or impending violation as a claim or defense against the state in a judicial proceeding. The person asserting the claim or defense may obtain appropriate relief, including but not limited to injunctive relief, declaratory relief, and compensatory damages. person prevailing on a claim to enforce a person's rights under Article 2, Section 12 of the Montana Constitution, or through 49.1, 208, 49.1, 210, and this is under the Human Rights chapter, must be awarded reasonable attorney fees and costs. Definitions. This is the fun part. Definitions are everything in law, guys. Unless the context clearly indicates otherwise, the following definitions apply. Burden means to directly or indirectly constrain, inhibit, curtail, or deny a person's right to bear arms, or to compel any action contrary to a person's right to bear arms. I think that includes calling in Big Brother to do your job for you. The term includes, but is not limited to, withholding benefits, excluding the person from government programs, or assessing criminal, civil, or administrative penalties. Compelling state interest means a government interest of the highest magnitude that cannot otherwise be achieved without burdening a person's right to bear arms. Person means an individual, association, partnership, estate, trust, foundation, or other legal entity. You guys didn't see an individual on there, right? It does say an individual, but believe it or not, if you start going into law, an individual is a corporation. It's a business entity. Look under UCC, you'll find an individual being listed as a business entity. It doesn't say the people. If you look under the law and define what people is, they're starting to define it, but you and I are the people, and they like to call us citizens, but that's bullshit, because we didn't sign no contract to obey the laws. We instituted the government for our protection, so we're not citizens. We're the people that are supposed to be protected by these pricks. Citizens are the government agents. They took an oath to obey our laws, so they are citizens of the United States. They are subject to the jurisdiction of the United States, and any foreigners who come in and naturalize. You know, they sign a little contract that says, senor, I obey all laws. Why do you think foreigners actually know the law? Why do you think you see these foreigners, First Amendment auditors that are like, oh, you can't do that, because they've read the law, because they signed a contract to obey it. So it is their duty to understand it. And they know it better than most Americans because, well, we didn't sign no contract. We're just supposed to be protected. Right to bear arms means the right defined by Article 2, Section 12 of the Montana Constitution. You can also find that same right under Amendment 2 of the Bill of Rights. State means the state of Montana or any political subdivision, local government, municipality, or instrumentality of the state. Well, the ATF is an instrumentality of the state, or the state's an instrumentality of the ATF. They're all part of the same big bird. I don't care what side of the wing they're on. I don't care what way it branches, whether it's an octopus or a seven-headed dragon or what. It all attaches in the middle somewhere. You know, it's all ran off of the same dirty fiat money, these promissory notes that the only value behind them is 7.25 menial, or 7.25 banknotes for a menial hour of labor. So, you know, I have to put this out there. I'm frankly pissed off. ATF raided my house. They kidnapped my child. They're trying to use him against me for an illegal contract made 23 years ago. I was charged with aggravated kidnapping, which is funny because aggravated kidnapping is a violent crime. But the judge specifically said there was no violence in my crime. So, I mean, it shouldn't even have been aggravated kidnapping. And honestly, due to the situation, it should have been a false arrest because I was told by a legal authority to take matters into my own hands, and I was given names to start my investigation with. So, you know, that seems kind of like I had been deputized. You know, it seems kind of like the burden had been put on me. And then, you know, they don't like the way I dealt with it. You know, but I will admit, nobody was harmed. I can live good. My conscience is clean regarding that situation. So, I did get sold into slavery over it, but that's a whole different issue we will be getting into. So, I mean, I'm frankly pissed off. The state abrogated its own statutes. It violated my fundamental rights. It came into my house. It took articles of liberty. And then, believe it or not, it tried to turn my child, my 7-year-old son, who they have a no contact order against because they wanted to use him as a witness against me, which let's get into that too. They wanted to use my 7-year-old child as a witness against me in a court of law, which is just frankly disturbing. And what did they want to use them against, witness against me? Because we owned firearms, a fundamental human right. Now this is a good one too. This is under human rights. Right to protection from personal injury, besides the personal rights mentioned and recognized in other statutes and subject to the qualifications and restrictions provided by law, every person has the right of protection from bodily restraint or harm, personal insult, defamation, and injury to the person's personal relations. So technically, Montana, especially my county, is involved in crimes against humanity. They took my 7-year-old child. They want to use him against me to imprison me for exercising basic human rights in the privacy of my own home, all because they gave me a fake lawyer 23 years ago and created an illegal object. And believe it or not, I've challenged that object many, many times. I have documents from Montana Supreme Court. 5 judges signed it telling me I can't challenge it, which is kind of funny because 2 of those judges were conflicts of interest. So there was only 3 judges who legally signed it, which makes an invalid judgment. So why I'm getting invalid judgments from Montana Supreme Court, well, that's a pretty big fucking issue. And I have the authority to arrest them. I don't have the ability, but I do have the authority. And I have ordered for several of these guys' arrests. And, they don't want to talk about that. So we're going into federal court, guys. And Jesus, this was 40 minutes. I'm sorry about that. But yeah, so hopefully I can find your all support in the federal courts. None of us like the law, but we're all required to live by it. And I did try to live by the law. I privately own guns. I've called out corruption. I've admitted waste, fraud, and abuse to the public officials, and they don't care because they're the ones committing the waste, fraud, and abuse. So now I'm looking to exercise, believe it or not, the Second Amendment in Montana allows the people to abolish the government. And there is really not much to abolish when they've already admitted that they've been committing illegal acts for 50 years. Now, the other issue is all these people who have done dangerous things, who have been put in prison to protect us, well, technically, we're not protected from them because they're not legally in prison. And if you're not legally in prison, we can't legally keep you there because that's involuntary servitude and slavery. And we don't do that, right? We have all these laws to protect against. Oh, here's another good one. Involuntary servitude and slavery. Juneteenth. Have you all heard of Juneteenth? Juneteenth is a national holiday of the federal government where they celebrate that involuntary servitude and slavery doesn't happen anymore. It is not in the United States, but we have 50 years of documentation showing that involuntary servitude and slavery is happening by the state corporations against you, against me, against our children. And it's got to stop. That's where I'm at. It's got to stop. The power needs to go back to the people. Everybody has the right to be safe, protected. Here's the thing, the political system. Look at the Second Amendment. Look at how many cases are argued on the Second Amendment. Look at how many millions of dollars of these federal promissory notes are milked into the court system to argue about a law that we set that says you guys aren't to be arguing about it. There's nothing to fucking discuss. Shall not be infringed. Shall not be infringed. And we go back to that right of loyalty and striking. So anybody who wants to discuss whether the Second Amendment shall be infringed is being disloyal to the U.S. Constitution. And A, they are not one of the people's representatives. And B, pursuant to law, they are to be put in a cage. If I have to obey the law and I'm not getting paid to do it, all these lawyers were paying to obey the law, need to obey the law. Need to obey it like it's the golden rule. Need to obey it like their freaking liberty depends on it, because under law, their liberty does depend on it. But the problem is, you got this bar association that says, we're not going to prosecute our own. We're going to conceal those crimes and protect them. The judicial is pushing us into a civil war. The other branches, state and federal, are allowing it. Wake up, people. Wake up. I love America. I hate the politics, but the people in the land are freaking amazing. You guys never cease to amaze me, but we need unity, people. We need unity. So let's get it together. Let's throw their own laws back in their face, because we're the ones that are supposed to be protected. This is our trust. We are the beneficiaries. Thank you.